Welcome to Medmarc's webinar series. Today's presentation is titled 2 Years and Counting, an update on the PrEP Act and COVID-19. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenter, Jordan Lipp, thank you for joining us. Jordan Lipp is a litigator who has enjoyed wide-ranging success both in the courtroom and through motion practice. He wrote the book on product liability law in Colorado. He's the author of Product Liability Law and Procedure in Colorado, and is one of the leading product liability defense attorneys in the Rocky Mountain region. He has successfully defended some of the largest recent jury trial product liability cases in Colorado. Mr. Lipp represents virtually all types of companies regulated by the FDA, including pharmaceutical, medical device, dietary supplement, and food companies. In addition to his legal practice, Mr. Lipp is also an adjunct law professor at University of Denver's Sturm College of Law, where he teaches outdoor recreation and ski law. And with that, I am pleased to turn things over to Jordan.
Thank you, Kate, and good afternoon, everyone. Welcome to what is now essentially the third annual PrEP Act webinar, and I want to thank Medmarc for putting these on now in our third year of watching how the PrEP Act has been evolving and how courts have looked at the PrEP Act in light of the COVID-19 pandemic. The very first webinar now has, beyond the initial participants, 647 views on YouTube. So maybe not quite a YouTube music video style following in views, but still for what for most people is an arcane area of federal law, it certainly garnered some recognition. But it's funny, right? I think for most people, this is an arcane area of law. But for the people who are attending this webinar, either live or will be listening to it later on, this is hardly an arcane area, right? This is one of our key protections as we are producing drugs and medical devices to combat the COVID-19 pandemic and other pandemics. And so I wanted to start, I assume pretty much everyone who is watching this is familiar generally with the PrEP Act, but forgive me, let me spend sort of 30 seconds going over it. As you know, it's a fairly short law. It's only about 6 pages when you print it out, which by federal standards is very short. And there are only 2 sections to it. There's section 6D and there's section 6E. Now, section 6D is what people are primarily interested in, which is the immunity provision. This is what protects manufacturers and distributors, and to a large extent, even prescribers, from getting sued for products that are combating a declared health epidemic or pandemic. Here, obviously, we're going to be focusing on COVID-19, but as this talk progresses, we're going to look back some at the H1N1 declaration because it's informative as we go through the COVID-19 process with the PrEP Act. So a few quick key terms, a quote-unquote covered person is the person or entity that is protected, that gets the liability immunity from the PrEP Act. And then the quote-unquote covered countermeasure, that is the product that the covered person is using for which they get immunity. So when we say covered countermeasure, we're thinking here obviously of drugs, devices, biologics. And for those, it's the same thing whether they have gone through the EUA authorization process or are actually approved or cleared drugs or devices. Which is going to be interesting when we look about what happens once the pandemic is truly over and the declaration stops. Well, we obviously are no longer going to have these EUAs. So we'll get to that in a few minutes. But that's the first section of the PrEP Act. That's 6D. But I wanted to actually start our presentation where I've never started any of my PrEP Act presentations before, but with section 6E, because I think it's really going to show us what's been going on with the PrEP Act when we start with section 6E. Now, what is section 6E? That's the part that creates the Countermeasure Injury Compensation Program, or CICP. And this Countermeasure Injury Compensation Program was first put in place in 2010. Remember, we all think about the PrEP Act in terms of the COVID-19 pandemic, but the law was first enacted in 2005, and it's been through multiple prior declarations. And so I think it'll be beneficial for us to look at how that program is played out. Now, first off, people are informed about the CICP, the Countermeasure Injury Compensation Program. Up on the screen is a screenshot when I got my initial COVID vaccine. This is the vaccine consent form that I filled out, and it provided me with all the information about the CICP before I ever got my first COVID shot. And for those of you who are looking at this and thinking about it, yes, I am such a legal nerd that not only did I read this language multiple times, but I also took a screenshot of it and then felt the necessity to share that screenshot with all of you. So yes, I'm a legal nerd, but this is important to think about because everyone who's gone through the COVID vaccine, or most people who have heard about the CICP. Do they remember it? That might be another question, but they've seen it. And what have we seen in terms of CICP claims? Well, there have been approximately 7,500 claims as the last time that the government compilated data, which was on April 1 of 2022. 7,500 claims of serious adverse events related to COVID countermeasures. So how does that break down? Well, roughly 60% of them were COVID vaccine related, and roughly 40% of them were other countermeasures. So when I say other countermeasures, what am I referring to? Well, it's hard to get exact numbers. The government does publish numbers, but they don't add it up anywhere. But when you just sort of scroll through the list, it looks like these other countermeasures, the big hitters are ventilators, hydroxychloroquine, and intubation. But there are claims that have gone to the compensation fund for every imaginable COVID related countermeasure. There are claims about N95 masks. There are claims about COVID-19 diagnostic tests. So it's a panoply of various products that we're seeing claims in. So then the question is, or at least a question that I think should interest us, is comparing the COVID CICP fund with prior CICP claims and payments. Well, here's where the numbers start to break down a little, and let me pre-apologize. When you actually go to the HRSA website and you start digging down into their numbers, the numbers don't quite add up. They're close and they give us a good directional sense, but they're not perfectly accurate. The numbers don't all match. And look, I get it. I'm bad at math too. But with that, roughly we're talking about 500 non-COVID claims have been submitted to the compensation program. So what have we seen in terms of payouts? Well, of the roughly 7,500 COVID claims, 99.8% of them are still in the pending phase. One of them has been determined to be eligible, and there is the calculation now on the expenses. 13 of them have been denied, but the vast majority of these cases are still pending, which is interesting because these claims started almost immediately after the COVID pandemic started. So some of these claims, while they've only been sitting around for 6 months, other claims have been sitting around for 1.5 years or almost 2 years now. So if we're trying to get a sense of what is the compensation program doing or what is the compensation program not doing, we can look back to the past claims for prior pandemics. So what do we have for that? There have been approximately, again, the numbers don't add up on the HRSA website, but there have been approximately 500 claims. A little less than 10% of them there have been compensated, and then the majority of them have been denied, these claims, for a host of different reasons. But of the 30 claims that have been compensated, the total amount paid has been over $6 million. So we're talking about some real compensation, even if it's a smaller percentage of people who have been compensated. So I've gone through all these compensation numbers just at the beginning of this webinar because I wanted to give everyone a sense of what's going on in the compensation program. because this really goes to the heart of what's the critical issue, I assume, for everyone who's listening, and for me, which is what is happening in the product liability world. And obviously, when I talk about product liability, these are lawsuits alleging that a countermeasure is defective, where the manufacturer or distributor or importer of that product gets sued. And so when I gave my first webinar on the PrEP Act, right at the beginning of the crisis on March 31st, I was optimistic. This is one of many quotes that I could pull out from my initial webinar, in terms of how it looked like the PrEP Act was going to broadly apply and provide great immunity. And so then a year later, when I gave my second webinar, I continued to remain optimistic. Now, right, no lawyer is going to be purely optimistic, and I would caveat it and give buts, but overall, the view was good, right? That the PrEP Act should be providing product liability protection. So now we are over 2 years in. We have the ability to see 2 years worth of case law on the PrEP Act. And what are we seeing? Well, I think we could look at this in a different way. My initial prediction, it was almost like a hypothesis. The hypothesis was this: the PrEP Act is going to prevent product liability lawsuits. And we are not through the testing phase so far, right? We're just about to start hitting the initial statutes of limitations for cases for products that were used right at the beginning of the pandemic in states that have the short end of the statute of limitations for product liability lawsuits, which is 2 years. Of course, the COVID pandemic is continuing, if albeit mostly abated now. The declaration is still in force. There are still EUA products everywhere. And some states' product liability statutes of limitations are as long as 6 years. So the full results from this hypothesis won't be in for a while. But we do have a lot of interim results. We have a lot of preliminary results because we've been in this process for 2 years. So how many product liability decisions are there from courts on the PrEP Act? These are decisions that are, of course, publicly available. They're not some state court judge that issues a 2-page order that doesn't get picked up by Westlaw, but of the actual orders that do get picked up, we have a grand total of 2. Now, I don't think 2 years ago, any of us were optimistic enough to think that 2 years later, today, we would only have 2 product liability decisions on the PrEP Act. And funny enough, one of them predated the PrEP Act. But this tells us something, right? This is telling us that the PrEP Act has been working. 7,500 plus claims under the CICP. We have had over 200 decisions in the nursing home context, and I'll get to those later on. But when we are looking at product liability claims and decisions, we have a grand total of 2. So what are they? The first one is Keller versus Hood. This was from the H1N1 vaccination. And by the way, when we looked at those compensation fund numbers earlier, and I told you that there were 30 claims that had actually been paid from prior pandemics, most of those 30 claims were actually from this H1N1 vaccination. But the Keller versus Hood was an H1N1 vaccination case that was a mix of Medmalum products. Plaintiff sued the doctor and the clinic where he received the H1N1 vaccine, and then the doctor and the clinic third-partied in the vaccine manufacturer. The vaccine manufacturer removed the case to federal court, and the federal court held first that the vaccine manufacturer could not be held liable because of the PrEP Act and dismissed that portion of the case. And then the second ruling, which is very interesting in light of everything that's happened since then, is that there was no federal court jurisdiction for the medical malpractice claims against the doctor and the clinic, and kicked the case back to state court. And I presume most people on the call are going to be fairly familiar with this language when I talk about removal state court and federal court, but very quick primer on that. So if a lawsuit gets filed in a state court as opposed to a federal court, the defendant can try to remove that case, that is, bring the case up to federal court. And once it's in federal court, the federal court has to have jurisdiction. In a traditional sense, most cases get removed based upon what's called diversity jurisdiction, which means that the plaintiff and the defendant are located in different states. But there are other bases for removal, and we'll talk about that in a few minutes. But because the plaintiff and the doctor and the clinic were in the same state, there was no diversity jurisdiction, and the court said that these other bases of jurisdiction that the PrEP Act might have given them were not applicable to the doctor and the clinic. So that's the Keller case. But PrEP Act, as the manufacturer, what most of us care the most about, that applied. So now that brings us to the one and only publicly available product liability decision that we really have right now in the COVID time. And that is a lawsuit alleging injury from a hand sanitizer and a lawsuit against both the retailer and also against the manufacturer of the hand sanitizer. The defendants in this case filed a motion to dismiss the complaint based on the PrEP Act, and the judge denied the motion and said it's too early because when you look at the face of the complaint, we can't figure out whether the PrEP Act applies. And there are a few reasons for that. One, early on in the PrEP Act, there was a more limited modes of distribution that the PrEP Act applied under, and the judge said, we don't know the mode that this hand sanitizer was distributed in. The second thing that the judge said, which is interesting and a good point, was that we don't even know from the face of the complaint whether the hand sanitizer was created and sold before the COVID-19 pandemic and before the declaration of the secretary that first started the PrEP Act applying to the COVID-19 pandemic. So because of that, the judge left plenty of room open for a motion for summary judgment once there was more discovery, but denied the motion to dismiss as to the manufacturer as well as the retailer in this Abicoli decision. So those are our two decisions. Let me then talk for just a minute. Do we have many cases going on in the courts, right? Sure, we only have two decisions, but do we have a lot of litigation going on under the PrEP Act? Well, that's a nearly impossible question to actually research and find the answer to, just because we have all these different state court dockets. They're not on similar systems. It's not all picked up. So when you do various searches to try to find cases, you're of course finding fewer than there are going to be overall. And predominantly what you can find are federal cases. But I'll tell you, even when you start searching around for product liability cases involving the PrEP Act, there aren't many of them. I put on the screen a few of the ones I was able to find, though, trust me, there just aren't that many of these. So there's the Abicoli case that we just talked about. Interestingly enough, the Abicoli case settled before there were dispositive motions. There are two pro se COVID-19 vaccine cases. I'm sure there are more than those, but those are the ones that you can find pretty easily. And then there was a hand sanitizer class action lawsuit that the defendant raised a PrEP Act defense, but that was dismissed on other grounds. So when we're talking about the universe of lawsuits against manufacturers involving COVID-19 countermeasures, they just aren't there. There just aren't too many of these. So, you know, if you ask me, is the PrEP Act working so far, at least as it was intended to? I would say it absolutely is. Now, as Harry Truman once famously remarked, please give me a one-hand economist. Every economist they ever talk to starts with, on one hand, gives an answer, but then goes to, well, on the other hand. And I may not be an economist, but lawyers are the exact same as economists, and I may not. I may be more of an octopus. So there's more than another hand on this one. And I thought, let's start in sort of the classic pharmacy and clinic type cases that we've been seeing that involve the PrEP Act. And I picked a few of them here, and I think they're interesting. The first one that's up on the screen is the Mills case. The Mills was a state court case, and it's important for us to remember that a lot of the PrEP Act litigation is actually going to be going on in state court. And this one was a case where the plaintiffs, or I think it was the plaintiff's estate, sued a hospital for care rendered while there were questions about whether the plaintiff had COVID and then afterwards. And what the court did was the court split the baby and said, the PrEP Act protects the hospital up to the date that the hospital knew the patient didn't have COVID-19. But once the hospital knew the patient didn't have COVID-19, the PrEP Act doesn't apply after that. There was a case from before the pandemic under the PrEP Act where a state court of appeals, this is the Parker case, held that the PrEP Act provided immunity for the doctors and public health department who were giving vaccinations. And then, just as a reminder, we'll get to these removal cases before. I presume most people are familiar with them. But in the pure med mal context, or in the pure pharmacy clinic type context, courts are not saying that the PrEP Act provides a basis of removal, a basis to case in the federal court. And so these are three decisions. I want to give a couple examples as well of ongoing cases in this sort of arena. There are a case where plaintiff goes in and is told they're getting the flu vaccine, but gets the COVID vaccine by accident. There's the diagnostic test false positive and the harm caused from that. There is the, excuse me, I got a COVID vaccine and then I wasn't monitored and I fell and hurt myself in the next 15 minutes style claim against the clinic. That one, by the way, was dismissed voluntarily by the plaintiff. So we're seeing a smattering of these cases, but not a lot that involve the PrEP Act. So the one thing that I've alluded to, but we haven't really spoken about yet, is the monster out there of these nursing home decisions. Now, there are currently today about 250 or so cases that have addressed the decisions by the court that have addressed the PrEP Act and COVID-19. And of those 200 to 250 decisions, the vast majority of them follow almost the exact same fact pattern. The decedent is a nursing home resident. He or she contracts and dies from COVID-19, or some related complication. And then the estate sues the nursing home for not having sufficient COVID-19 precautions in place, masks, social distancing, et cetera, et cetera. And so these cases have been removed. The nursing homes, when they get sued, have removed a number of these to federal court, arguing one of three things, really. First of all, that they can remove this case to federal court based upon complete preemption. That is, the PrEP Act completely preempts the state law, and the only place where you can sue is federal court. The second one is substantial federal question. That I wrote in here, Grable, that's the case that people generally cite for substantial federal question, that the PrEP Act raises substantial federal questions. And then the third one is federal officer removal. And so the nursing homes have been removing these cases to federal court, and with only less than a handful of exceptions, and to the best of my knowledge, only one decision on Westlaw. There are a few decisions that are not available on Westlaw that came out the same way. There's only been a small number of cases that have said, yes, you can remove it. The vast majority of cases have said these sort of cases are not removable to federal court, these nursing home cases. Rather, the federal court doesn't have jurisdiction, and it's up to the state court to decide the applicability of the PrEP Act. We're now at 3 Court of Appeals who have heard this and have ruled against the defendants and bounced the cases back to state court. That's from the 3rd, 5th, and 9th Circuit. I believe there were arguments the other week in the 11th Circuit on this issue, and so more Court of Appeals are going to be weighing in. But so far, in general, the vast majority of courts have been saying these cases are not removable. So let me add a few caveats to what I just said. The first one is that although the vast majority of these cases are nursing home cases, there is a small group of them that are more classic hospital clinic cases. There's one, for example, where just for something different, where a physical therapist did a home visit and the plaintiff sued, contracted COVID-19, and then sued the physical therapist and the physical therapist company, saying you didn't have proper precautions when you visited me in the home. These are not all nursing home cases, but the vast majority are. And these cases, in general, the courts are saying you can't remove them to federal court. Now, just as a reminder, none of this has to do with diversity jurisdiction. So if the residents of the plaintiff and of all the defendants are different, then you can remove the case to federal court. So we have all these nursing home decisions, and there are some troubling aspects, because when the courts have talked about what the PrEP Act is and what the PrEP Act is not in the complete preemption context, they've been, I don't want to say whittling away, but lowering the importance of the PrEP Act to support the grants of remand of these cases from the federal courts to the state courts. But we certainly haven't seen any impact of that yet in the product liability world. Now, I think one of the key points in a lot of these cases is the question, are we talking about the use of countermeasures, or are we talking about the failure to use countermeasures? So case after case after case has said that the PrEP Act is designed to protect those who employ countermeasures, not those who decline to employ them. And so, right, the nursing home cases, or even the physical therapist case example that I just provided, right, those are allegations that countermeasures were not used. And we're not just talking about countermeasures here as well, right? We're talking about social distancing, et cetera. So that's an underlying theme, and that brings us to an interesting question. So for the PrEP Act to apply, the secretary has to make a declaration of a public health emergency and set out the scope of the PrEP Act coverage. And the declaration was obviously made here. It's been amended now 10 times. But the most important amendment was the 4th Amendment, because it actually republished the declaration in full. And one of the questions for that 4th Amendment was, well, how do we deal with this question about the failure to use countermeasures in a world of limited resources, a world that we obviously live in, and has been particularly acute during much of the COVID-19 pandemic? What happens when you only have so many vaccines and you have to choose between who gets them and who doesn't? Well, the secretary in the declaration basically said, look, if you're purposefully making a decision that someone doesn't get the vaccine or whatever countermeasure it is, because it should be prioritized to someone else, that should be protected under the PrEP Act. And this makes sense, by the way, when you actually read the language of the PrEP Act, because it's not just use the countermeasure, it's administered, related to, et cetera. This language has been discussed by a few courts, not always in the best context. Here's an interesting one from Oregon that I put up on the screen, where it was a lawsuit by prisoners against the state of Oregon for not including them in round 1 of the of getting the vaccine. And the court said, well, I've read this 4th Amendment very carefully, and it said that this decision to use or not to use should be done, quote, in accordance with a public health authority's directive, unquote. And the CDC was saying that prisoners should get vaccinated at the same time as the prison guards. So the PrEP Act does not provide immunity to the state of Oregon. So kind of a difficult and tortured analysis, and not a great one, but that that case sort of gave us sort of that outer sense of where we might be able to argue the use or lack thereof portion of the PrEP Act. So with all that, we've been going for a little while now. I wanted to talk about what conclusions can we reach now that we're a little over 2 years into watching the PrEP Act work under the COVID-19. Let's start with a first and obvious conclusion. The PrEP Act has all but eliminated product liability lawsuits. How can I say that? Well, we have 7,500 plus claims for the compensation fund. Virtually all of those could or would have been product liability lawsuits in the absence of the PrEP Act. But the PrEP Act is here, they're not lawsuits. Now, let me caveat that statement that I just said, because the statute of limitations for the CICP is 1 year after administration. So it's quicker that the claimants have to move forward to file their CICP claim paperwork than it is for them to file a lawsuit. However, look at the nursing home context, right? We've had over 200 decisions now in the nursing home context. So we can see that there was a rush, a wave, a large amount of nursing home PrEP Act litigation. That has been entirely absent in the product liability sphere. So I think when we take the two pieces here, the number of claims, the CICP, and the amount of nursing home decisions, we can say pretty well that so far the PrEP Act has all but eliminated product liability lawsuits. What's the second lesson that we can learn after these last 2 years? Well, it's that the PrEP Act in and of itself is generally not a basis to remove a case to federal court. Right, there's now been 3 circuits that have spoken to this. The vast majority of district courts have come out, I would say the wrong way, but have come out to say that the nursing home cases cannot be removed to federal court. And so I don't think that necessarily defendants should be looking to make their PrEP Act arguments in federal court, though of course there's diversity jurisdiction or other bases. It's usually, though not always, good to be in federal court. The third lesson, and frankly, look, this is not surprising, is that courts generally find that the failure to use a countermeasure is likely not protected by the PrEP Act, right? The PrEP Act applies to the ventilator, to the vaccine causing injury. And if you're not using those products, we're not that much into the PrEP Act world. So those are sort of, as we're 2 years into watching the PrEP Act work, I think those are some of the main takeaways that we have. But of course, as big of a question is really, what's ahead of us? Now, this is an interesting question, and for those who have heard my prior presentations, not to repeat myself, right, but there's a great old quote by Yogi Berra that never make predictions, but if you're going to predict something, predict the past. And I tend to violate that a lot, but obviously we have to take all predictions with a grain of salt. Let's talk about the first issue that we're facing. That is that at some point, the PrEP Act is going to sunset as the COVID-19 pandemic. That doesn't mean the statute is going to sunset, right? The statute is out. But, excuse me, the PrEP Act only works in conjunction with the declaration from the secretary. And the declaration, by its own language, can either end when it's withdrawn, so to speak, or on October 1st, 2024, whichever comes first. So there is going to be a day in the not too now distant future when we will no longer have this PrEP Act protection for COVID-19 countermeasures. Now, what does that mean? For those who attended Dr. John Lin Song's excellent presentation from March 22nd through Medmarc about those next steps, right, from a regulatory standpoint, manufacturers can transition their products from EUAs over to cleared or approved devices, or withdraw them. And I would encourage you to listen to that webinar if you haven't already, to get sort of that whole regulatory process. But even with however that transition goes, we all know that there are going to be products that are intended to have been withdrawn from the market that are going to be sitting around in hospitals, right? There's going to be that connector tube for a ventilator that even that went out under an EUA authorization that would get pulled back under normal circumstances. And no matter how much we try to pull it back, right, there are going to be products floating around out there that were created for COVID-19 and that will not have the PrEP Act protection someday, right? So that is an area of concern. And it's a particular area of concern when you figure that, right, under an EUA, technically you don't even have to follow CGMP. And so there are going to be all those products there. I'd call them orphan products, but I mean, that's sort of a term of art as we know in our industry, but conceptually, right, they're going to be out there. Then there are going to be all the products that convert from an EUA to an approved drug, biologic, or cleared device. And once that happens, those products are going to eventually, not because of their conversion to an approved or cleared or licensed device, but once we've hit October 1st, 2024, or whenever this declaration ends, at that point, they're going to be out there, they're going to be used whether to deal with the endemic portion of this or to treat people unrelated to this public health crisis. And then those products can face lawsuits in the same way that any other product has ever had without that PrEP Act protection. So in a nutshell, we know that there's still a category of products that are out there. Someday they're going to lose some portion of PrEP Act protection unless we see different regulations or statutory changes to the PrEP Act. So there's that piece to be concerned about. Obviously, and I haven't said this yet, right? There are other questions or concerns about the PrEP Act. The biggest one, of course, is it's an American statute, and most of you or most of your clients sell products not only in the United States but in many other countries, and in many other countries we're not seeing the same protection that we get in the United States from the PrEP Act. There's also still that fascinating question, which happily, because there haven't been these lawsuits, but hasn't been addressed by the court, about what do we do with products that were created for COVID but are being used for non-COVID purposes in the hospital. Now, remember, under the PrEP Act, for example, the influenza vaccine has fallen under the COVID declaration, right? The idea is that the people need to be taking the flu vaccine, so people with the flu are not filling up hospital beds that were hopefully meant for COVID patients. But think about all sorts of other contexts, right? So rush to produce anything, whether we're talking about ventilators or nasal cannulas, right? A nasal cannula gets produced for COVID-19, but it's not as if a hospital necessarily, even if they should, not necessarily keeps that nasal cannula for the COVID-19 patients, right? So that product is getting to all sorts of other patients. And so we have this question of, let's say that there's a contamination in that cannula, and that a non-COVID-19 patient uses that and gets injured. I think we're all comfortable saying that if it's a COVID-19 patient, that the PrEP Act should definitely apply there and should bar that lawsuit. But if it's a non-COVID-19 patient, that's a more murkier. So we're still waiting to see, right? Will there be litigation in that space? So there are these risks, there are these holes. The PrEP Act is not perfect. but it's also certainly not Swiss cheese, right? I want to end this by saying I think we should all be very pleasantly surprised that we're 2 years in and we have not seen a rash of product liability lawsuits. There have frankly been more securities lawsuits involving COVID-19 countermeasures than there have been product liability lawsuits. So the PrEP Act is working, and fingers crossed it's going to keep working to help protect all these drugs and devices and biologics that we've produced to combat the pandemic. So with that, I want to turn it over to questions.
Thanks, Jordan. We do have a couple questions for you. I was wondering if you could talk a little bit more about the compensation fund and whether there are any claims in the compensation fund at the moment that mirror the nursing home claims.
Yeah, that's a fascinating issue, and it'll be interesting to see how that plays out in the fund. So there, in the list of styles of countermeasure claims, there are 290 something claims that seem to mirror the nursing home style claims, where it's the failure to use countermeasures and the failure to put in processes and people alleging that they were injured because of the lack of countermeasures or the lack of adequate countermeasures, which is going to create an interesting question, right? To the extent that some of those nursing home cases, well, some of them have already been decided unfavorably on the PrEP Act, but to the extent more of them are, what will happen with the fund, right? Will the fund be paying out for those, or are those cases that rather appear to play out in litigation? So we'll have to see how that plays out. Of course, from a timing perspective, we really don't have a sense of how long it's going to take the CICP to make these determinations. The VICP, as folks know, moves slower than most courts move. And so, right, assuming that the CICP is similar, the VICP is, the vaccine fund that was the 1986 Childhood Vaccine Act that created a separate vaccine fund. But right, the CICP is kind of modeled on the VICP, and there's a slow process. So I don't know when we're going to get the answer on that nursing home style claim question from the CICP.
For drug and device manufacturers, if they have a lawsuit for a COVID-19 countermeasure, can the drug or device manufacturer remove the case to federal court?
So there are a few pieces to that, right? I mean, think about the typical case where hypothetical, I get the vaccine. I live in Colorado. I have an adverse reaction, and I decide I'm going to sue Pfizer or Moderna. If I just sue Pfizer or Moderna here in Colorado, there's obviously diversity jurisdiction, right? Pfizer or Moderna can remove the case up to federal court based solely on diversity. You don't even have to worry about the PrEP Act. Of course, a number of these lawsuits, the Colorado resident, the plaintiff suing, would also sue the clinic and or the doctor for the vaccine. And in that case, right, we may not have diversity jurisdiction. So that raises the question, right? Will the courts view a removal by a vaccine manufacturer or a medical device manufacturer differently than they would view these nursing home cases? And the short answer is potentially. If you remember that Keller case that I talked about early on, the H1N1 vaccine case. So in that case, the vaccine manufacturer actually successfully removed the case under the federal officer removal statute because it was part of the federal government's rollout of the H1N1 vaccination. And the court found that that removal was proper. So there may be opportunities for the manufacturers and distributors that are not available in the nursing home to get the cases removed to federal court. So yes, in a nutshell, we have more possibilities in those cases than there were in the nursing home cases. But in any event, diversity is more likely to be present in those cases. And let's not forget that even if we're stuck in state court, the only appellate decision on whether the PrEP Act explicitly applies in a med mal context was a New York State Court of Appeals decision that did apply, and is pre-COVID. So we're, it's not the end of the world if we're in state court, though obviously we would rather be in many places in federal court.
And finally, one more question. Do you have any advice for companies, particularly those who were maybe not in the medical device space prior to COVID and who stepped up and started manufacturing PPE or other devices? Is there anything in particular they need to be thinking about doing to ensure that their products are not misused after PrEP coverage is no longer available to them?
Yeah, that's a great question. And let me actually back up and address the something that was maybe implied in that question. But right, a number of companies have been making product, have never been in the drug or device space before, and all of a sudden they find themselves in the device space. And that Avicoli decision that we talked about earlier, the judge explicitly wrote when in denying the motion to dismiss that we're not talking about one of those companies, right? Because one of those companies that switched over for the pandemic is the type of company that would fall under the PrEP Act. Now, that's dicta for the non-attorneys on the call. That's not legally binding what the judge said on that point. But it was a great point and a great area of comfort, right? That for all these companies that converted over to making countermeasures, right? The Avicoli judge sees that it's falling squarely within the PrEP Act. So I know that was kind of an aside, but let me move to the main portion of that question. What can you do? And I think the main answer is to, one, make sure that you're following that correct process with the FDA that there was the earlier webinar on March 22nd to convert the EUA over or to withdraw the product from the market, and make sure that you are doing a good job, whichever direction that goes, that you're working with the FDA through that process to the extent that we're able to work with the FDA on it. And then it's important for us to remember that, yes, the PrEP Act is this it's this golden arrow that provides us an immense amount of protection, but we're still going to have some protection in that sort of scary, I don't want to use the word orphan device, but these devices that are going to be floating out there afterwards, right? That there's still going to be, they shouldn't be used. Hopefully there's good labeling on the products explaining that. There's a lot of fault to be put on the hospital or other clinics that are still using products that they should not be using. So it's not the end of the world just to go back to life as it was, where you could get sued under product liability, but there is that outlying residual risk as the pandemic winds down.
Yeah, determining end of life seems to be a really challenging issue for device manufacturers, and developing things that were just used for the pandemic seems to have added this additional layer of complication for them.
Completely
so you
agree.
appreciate it. Yeah. Jordan, thank you very much for your time today. It's hard to believe that we've been talking about this for 2 years now, but it's really critical and timely information that's of great value to our audience.
Great. Well, thank you, Kate, and thank you, everyone.
Thank you for joining us. This concludes today's webinar.